What if I told you that the most dangerous thing a person could do inside a courtroom was speak? Not because of what investigators found, not because of what witnesses said, but because the accused handed the prosecution exactly what it needed, with their own words. According to court records across 5 separate cases, that is precisely what happened. A courtroom is designed to protect you. You have a lawyer. You have the right to remain silent. You are presumed innocent. And yet, time and time again, people throw all of it away because they simply could not stay quiet. Let's uncover it. The Case 1, The Whisper, Robert Durst. Robert Durst was a real estate heir linked, according to decades of investigative reporting and court records, to 3 separate incidents in which individuals close to him had lost their life. For decades, he remained free. In 2015, an HBO documentary crew recorded a series of interviews with Durst. At the end of the final session, he stepped away to use the bathroom, still wearing a live microphone, believing it had been switched off, but it wasn't. What he allegedly said in that moment was later admitted into evidence, according to court records. The following morning, he was taken into custody. In 2021, he was found responsible for the passing of women. A lifetime of alleged evasion ended by a whisper. Case 2, The Genius, George Trepal. George Trepal was a Mensa member, top 2% of measured intelligence worldwide. When a neighboring family began experiencing severe and unexplained illness, Trepal allegedly did not stay silent. According to trial testimony, he made dark comments, suggesting something unfortunate might befall those who remained living nearby. Investigators later established, according to court records, that beverage containers had been deliberately contaminated with thallium, a substance capable of causing catastrophic harm. The individual allegedly responsible was George Trepal. His own words had placed him in investigators' focus before a single item of physical evidence was formally connected to him. He was convicted. Intelligence means very little without the discipline to say nothing. Case 3, The Stand, Joanna Hayes. Joanna Hayes maintained a composed and controlled presentation throughout the early stages of her trial. She denied the allegations, calmly, confidently. Her legal team believed placing her on the stand would allow the jury to connect with her directly. Under cross-examination, as documented in trial records, that composure fractured, question by question. Her account began to contradict itself. Her voice became unsteady, and then, according to court records, she broke on the stand, in front of the jury. Through her own testimony, she allegedly confirmed what the prosecution had spent the entire trial working to establish. No further evidence was required. Case 4, A Decade Broken, Curtis Reeves. Curtis Reeves was a retired law enforcement officer. In 2014, according to court records, a confrontation inside a Florida cinema resulted in another patron losing their life. Reeves claimed self-preservation, that he had allegedly feared for his own safety. For years, the matter remained legally unresolved. Then, in 2023, Reeves chose to take the stand. Under cross-examination, according to court records, his account began to show inconsistencies. Details shifted. Timelines blurred. The jury did not see a man recounting a genuine act of self-preservation. They saw a person working to hold the story together under pressure. He was found responsible for the passing of man, nearly a decade later, because he chose to speak. Case 5, The Correction. During a trial for an alleged armed incident, the prosecution was presenting their timeline of events, almost entirely accurate. With one minor factual error, a small detail inconsequential to the case, that the accused noticed from across the courtroom. They interrupted. They corrected the prosecutor. And in doing so, according to those present, they voluntarily provided the precise sequence of events, the timing, the method, the details that the prosecution had been unable to fully establish through evidence alone. In fixing one small inaccuracy, they confirmed everything. Their legal counsel offered nothing further, because there was nothing left to say. 5 cases, 5 individuals who held the most powerful protection available to any accused person, the right to say nothing at all. And 5 who, for entirely different reasons, arrogance, fear, guilt, or simply the human compulsion to be understood, chose not to use it. The courtroom is the one place where your words carry the most weight. And yet, every single time, the silence breaks. What does it say about us that even facing the gravest consequences, we still cannot help but speak? Leave your thoughts in comments. Subscribe to The Last Verdict, because every story is waiting to be discovered.